Question of the day here. Can my wife get alimony if she purposely quit her job? Maybe. If she can show that her unemployment or lack of employment is not voluntary, then the court could find that her inability to become reemployed isn't her fault. The way to prove this is to show that you've applied to jobs, right? So the way she would prove that is to show she's applied to jobs. The way you would disprove it is probably by a vocational evaluation or an attempt to get her income imputed at the median income wage. That has a very specific procedure, and you'll have to request judicial notice of the U.S. Census Bureau of Information. I know, it sounds really simple. It's not. Erin Morse for your divorce. Is there a way to stop paying child support if the mother refuses to let me see my son? No. In the same way that if your failure to pay child support can't result in you not seeing your son. What you need to do is take her to court and hold her in contempt for not following the court order that allows you to see your child with your time sharing. You can't not pay child support. Those two things should not be connected. Your ability to see your child and the fact that your child needs support are not things that one begets the other. So failure to see your child and you're not making sure that you hold her in contempt of that is kind of your fault, right? So the first thing that the court would ask you when you were brought in on contempt for not paying the child support was, why didn't you file a motion for contempt? Why didn't you enforce your time? You can't take action on your own. It's called self-help. And you really can't engage in self-help to remedy failures to follow a court order. What should I expect at a court hearing after filing a petition in Florida? If you've simply filed a petition and nothing else, you shouldn't expect a court hearing. There are actually a lot more compliance that you're required to engage in before you can get in front of a judge. Locally in our county, you are required to attend mediation before you can get in front of a judge. And usually before you can go to mediation, you need to be compliant with your financial disclosure, including a financial affidavit and mandatory disclosure. So, what you should expect is to try to take a shot at mediation before your judge will give you a court date. And then there are a lot of steps in between filing your petition and actually getting a court date, and probably a period of 3 to 5 months. There are ways to get there quicker and ways around a lot of these procedures, but one of the best scenarios would be to come to a full agreement. How do I move to Michigan from Florida if I already have a final judgment? So one of the things you need is either consent from the other parent, and you need it in writing. There's a form that's available for free on the Florida Supreme Court website, or you need to file a petition for relocation, meaning you need to prove to the court why moving to Michigan for you and your family would be in the best interest of the minor child. One caveat: you have a very specific requirement on exactly how you need to file the petition for relocation. And if you don't file that petition for relocation correctly, it can be denied on its face for not following the statute. So petition for relocation is really your answer on how you get to move out of Florida. We received a question, and I'm going to answer it for you. First of all, you get your court order and you go pick up your son. No one's here to serve you. It's not like Domino's. They're not going to deliver your son to you. And the easiest thing for you to do would be to go pick up your son if you know where your son is, of course. The next thing to do would be to file a motion for contempt. If you succeed at your motion for contempt, either in that hearing or in the next one, depending on what's going on with your case, you could file a motion to request that the judge issue like a bench warrant, right? We call it a writ of bodily attachment. I've been able to do that in a couple of situations. So go get your kid. How about start there, right? If you think you need a police officer, go with your court order and have a police officer assist you. And then if you can't, the court is your next remedy, and then you can have her arrested if you request it. Sometimes it might take 2 to 3 motions for that. Good luck.